Yeah. It's only for those in the room.
Yes, it's
Thank you.
physical. Correct. Okay. Uh, and I'm going to speak in English. So those of you, أحكي بالإنجليزي. And do we have Mais? We have Mais. All right. So this is the last open session before we switch to a different format for this afternoon. And very happy and excited to be moderating this panel, frankly, because we have a fantastic set of panelists, but also because the topic is one that is very dear to my heart and goes to the heart of the issue of environmental justice. And so I think here, and I want to, I know some of you are worried that there might be too many of us lawyers on this panel, but rest assured, this will not be a legal lecture, though the law could be interesting, and I think when it comes to accountability is even essential. But we are going to talk a bit about litigating environmental damage. And at the heart of it is maybe for us to build a stronger and better understanding of how both international law, but also our various national laws, and we'll look at Egypt as an example, understand, approach, frame potential environmental crimes. Sorry, can we just turn off this thing? Looks like there's a mosquito behind us. And this is a topic where actually when we look at the MENA region compared to other parts of the world, it has received relatively little attention. There's been little reliance on strategic litigation to push for environmental protection in our national courts. There are some exceptions, but they remain exceptions. But also internationally, when you compare, for instance, the big court cases against oil companies that we've seen from many parts of sub-Saharan Africa, when you look at the cases that have been brought forward in other global South countries, India, South Africa, you can feel that there's actually a big potential and a big need to address this. So as we, for the benefit of time, I'll introduce our speakers as I ask them the first question. This will be an interactive panel. We'll go through two rounds of questions and then a set of recommendations and then open it up. And I will start with the first set of questions, really trying to explore more how do the different legal frameworks, and when I talk about legal frameworks, here I'm talking bodies of law, right? So there is the laws of war, what's known as international humanitarian law. There's human rights law. There are specific laws around the environment. We'll talk about maybe laws around water governance and so forth, and national laws. How do they approach, think about crimes against the environment, and how do they approach crimes against the environment during peacetime versus during wartime? And to start, I'm going to actually first go online to Dr. Mais Qandeel, who I believe is here with us. Hi, Mais. Mais is a senior lecturer of international law and technologies with more than 15 years of experience, both at national and international human rights organizations, institutions in various countries. I think she really blends strong expertise on international humanitarian law. International humanitarian law, by the way, is just another way of calling laws of war, also known as the Geneva Convention. So don't be intimidated by these words. And also importantly, the intersection of, as well, international law and the question of Palestine, something we talked about yesterday, and I hope we'll explore even more today. She holds an LLM, a master's in law from international law from University of Pittsburgh, and a PhD in international humanitarian law with a focus on Palestine from University of Fribourg in Switzerland. She's authored many articles and a series of publications. But I'll just jump right into it, Mais, and maybe start by asking you to tell us, how does international humanitarian law think about, so these laws of war, about attacks on the environment? Can you explain to us how international lawyers have thought about attacks on the environment, how they get qualified, and how, yeah, what you'd like to tell us about this. And you have 4 or 5 minutes, please.
All right. Yeah. Thank you so much, Nadim. Before maybe going to the law or international humanitarian law, I think it's really, which is the law of armed conflicts or the law of war. Again, as Nadim said, don't be intimidated by the names. They're just fancy names at the international level. But I really think it's important to distinguish between applicable legal rules when. So, for example, at the international level, the law differs between the times of war and times of peace. So, human rights law, environmental law apply at all times. So it doesn't matter what type of situation we have those laws applicable. On the other hand, we have international humanitarian law or the law of armed conflict, which only applies in situations of armed conflicts. I'm not going to go through all of these details, but whenever we have a conflict, we have IHL applies or international humanitarian law. The application of international humanitarian law does not stop the application of other laws. So we would still have, even when it comes to situations of armed conflicts or situations of military occupation, we will still have kind of different bodies of laws that are applicable. At the national level, of course, all national legislations would be applicable. It doesn't matter what type of situation the country has. But also let's keep in mind that sometimes these kind of certain provisions of national laws are being halted. And this is when a country kind of declares a state of emergency. So this is kind of an important part. But now, now we know that the law of armed conflict applies whenever there is a conflict, which the names tells us. The idea of the law of armed conflict is basically to protect civilians, civilian objects, minimize their harm, and prohibit attacks against objects that are indispensable to the survival of civilian population. So we actually have not seen anything that protects the natural environment at the international level in the law of armed conflicts until 1977. And that was within the adoption of Protocol 1 and Protocol 2 as well of the Geneva Conventions. There are many treaties that we look at when we look at the international armed conflicts. But in general, these international rules, when it comes to the protection of the environment, they are very few, extremely few. So one rule that provides that it's prohibited to use methods or means, and now here we are talking about weapons, right? So what type of weapons are we allowed to use? Of warfare, which are intended to or may expected to cause widespread, long-term, and severe damage to the natural environment. And the long-term bit, I think yesterday, as one of the panelists talked about it, maybe we could take this later when it comes to what it means. But we have all three: widespread, long-term, and severe damage to the natural environment. So basically, the law prohibits using the destruction of the natural environment as a weapon of war, and it prohibits attacks against the natural environment as a target. So we are not allowed to target the environment as such. We are not allowed to use the environment as a weapon of war. And please, if I am complicated enough, just try to ask, and I could simplify. So even Protocol 1, it is a treaty, and it only applies to only these states who have ratified it, which means that if I am a state, I go to the international community and I say, I want to ratify this particular treaty, and I am bound by it. But these particular provisions, when it comes to the natural environment, and these are really two provisions, they have been established as customary norms, which means that they are legally binding on all states. And it doesn't matter whether that state ratified Protocol 1 or not, or Protocol 1 to the Geneva Conventions. So there are also two important principles that we look at when it comes to the protection of the natural environment. The first one is the precaution principle, and the second one is due regard, which means that we will have actually to look at what type of damage a particular military operation would cause, specifically to the environment. And if it's a severe damage, then we should not actually conduct that attack. And of course, there are many other treaties that do apply. So, for example, there is the United Nations Convention on the Prohibition of Military or any other hostile use of environmental modification techniques. And that particular convention really went to prohibit engaging in any military, the use of any environmental modifications, which is kind of very much specific to the natural environment. That particular treaty is really extremely few Arab countries or MENA region countries who have ratified it.
Guys, can I be on mute?
I'm sorry?
10-second, Mais.
All right. So we have, for example, only Lebanon, Tunisia, Syria, and Yemen who have ratified that particular one, but not the other Arab countries. So we have still, of course, a gap when it comes to the ratification of these treaties. I'll stop here.
Great. No, thank you. So I guess what we take from it is, so the laws of armed conflict were late to the game when it came to the protection of the environment. They tried to fill the gaps with the protocols signed in the 1970s. And if I understood you correctly, though some of the countries in the region, for example, I think Israel has not signed the additional protocols, these protocols have taken now, in a way, they've become customary law. They've become adopted by so many countries that they are applicable across the board. Though, I think, as you were saying, this is not necessarily the most progressive sorts of law. It's very much about, don't harm the environment. You have to think about whether this attack is really necessary, and are you doing, don't. Anyway, and generally the laws of war are quite cynical, but protective in nature. And I think we'll come back to it in a second about how, has this been enforced in our region and how. But thank you very much, Mais. And I'm going to just now switch to actually Christine Beckerle, who is a lawyer, researcher, human rights activist, and writer, and focused both on human rights and humanitarian law questions in the Middle East. She's actually today thinking a lot in her current role on some of the issues we're going to be discussing, which is how does human rights law as well approach questions related to the environment and socioeconomic rights, because she is the inaugural regional socioeconomic rights advisor at Amnesty International for their MENA division, and very much focused on this intersection of conflict, climate crisis, extraction, and socioeconomic rights violations in the region. She's done a lot of different things. We were colleagues at Human Rights Watch at different times. She was a fellow at Yale for the last couple of years, but also interestingly has actually tried to bring litigation to hold perpetrators accountable in this region, particularly in the context of Yemen, where she worked at Muwatana, one of the leading independent Yemeni rights organizations. So I think Christine, you're really well placed to kind of walk us through the next section, which is really thinking about how has human rights law approached things like, is there a right to a healthy environment? What does this mean in practice? How does, our right, what are the sort of methodologies, the challenges that you're thinking of? And how does human rights law frame it? Do we have a right to water? Like we've seen the Iraqis in the marches, do they have a right that this water is delivered to them? And more importantly, what does human rights law say about potential recourses?
Thank you, Nadim. Thank you, Mais. I'm very happy to be on this panel. So what I'm going to do is very briefly try and answer the questions that Nadim asked. But one thing I want to say at the outset is that I think myself, like many others in the kind of traditional human rights movement, have also been a bit late to the game on the environment and climate issues. And so right now what I'm doing is really thinking through what we can take from the human rights movement to make sure that we're using those tools to center climate and environmental issues. But, and if you take one thing away from what I say today, human rights is a part of the puzzle. It is not the answer. So I think sometimes we get lost in thinking that, okay, well, we'll go to this human rights body and that will solve it. It will not. Like, we in the human rights movement are fighting for justice. We are fighting for accountability. We are fighting for reparations. But like, you know, see. So I want to talk a little bit today about the tools that we can use within human rights law. And then in the answer to the second question, human rights fora, places we can go that are international human rights institutions to bring these claims. And I also want to talk a little bit about what's already happening, because I think it's easy to sort of pretend like nothing's happening, but that's not true. Like, there is actually some really interesting stuff over the last few years on climate and the environment within international human rights law. So on the law, as Nadim asked, do we have a right to a healthy environment? And the good news is, yes, we now do, but we only very recently do. So I think it was 2022 that the UN General Assembly finally recognized the right to a healthy environment. And this followed many, many years of efforts by experts, by local activists, by people in the climate movement, by academics, trying to say that we need a specific right on the right to a healthy environment. And we now have that. And what's cool is, because you have this resolution, because you have this recognition that this is in fact a right, you have a whole bunch of things that get put in motion, either be it funding or organizations or research saying, hey, how do we actually actualize this right? What does this right mean? But even before we had the right to a healthy environment recognized, you had people within the human rights movement at all levels using the rights that we already had, more firmly established rights, to go after climate and environmental issues. The kind of traditional one that people use is talking about civil and political rights, those kind of political liberties, as it relates to environmental rights defenders. And that's a very important piece of the puzzle, as we just sort of heard in the panel that we listened to. But what I want to talk about a little bit is how socioeconomic rights have looked at climate and the environment, particularly in MENA. So within the Convention on Economic, Social, and Cultural Rights, which is one of kind of the foundational human rights treaties that we've had for a long time, you have a whole set of rights that are obviously impacted by not just climate change, but some of the environmental things that we've been talking about, extractive pollution. And the key ones that people tend to focus on are the right to health, the right to food, and the right to water. There are a whole bunch of other rights within this treaty that do get impacted by these things, but I'm going to really zoom in on the right to water right now, because that's what I've been thinking about. And also, we've been talking about it a lot over the last 2 days, so why not focus? And one thing that's, for anybody who's interested, that I highly recommend you go check out, is all of these international human rights law treaties have what are called treaty bodies, which is basically groups of experts that monitor compliance with the treaty and also say, what does the treaty mean? They interpret it in light of things that are happening in the world. And the committee that oversees the Economic, Social, Cultural Rights Convention actually a few years ago put out a statement saying this is what socioeconomic rights mean in the context of climate change. And they specifically looked at, what do we require of governments, because international human rights law operates at the level of governments, when it comes to climate change. And I just want to highlight 3 things from that statement. The first one, on water particularly, they said the impacts on water from climate change are eminently predictable. We know what's going to happen. We know it's going to be a huge problem for people. We know it's going to impact people's rights to water. So you need far more urgent action from governments to be planning, to be preventing these harms from climate change on people. And they also say, if governments fail to take adequate action to prevent these knowable harms, then that could be a violation of the treaty. And I think that's quite important, because sometimes we think about human rights law as the harm has had to happen, but that's not always the case. We can also say, are governments looking at harms that we know are going to happen and taking the necessary steps to prevent them and to protect people within their jurisdiction? And I will emphasize, because we're in Jordan and the Middle East, it's people within their jurisdiction. So it's not just citizens, it's all people that are living within the territory. And then the final thing, which I think is quite important, particularly speaking as I am as an American, is that The committee also emphasized that it's not just the government where the people are living who have obligations when it comes to meeting people's economic, social, cultural rights violations, rights. They also talked about the obligation for international cooperation, which simply means that other governments, including global north governments, governments historically responsible for climate change, have obligations to provide funding, technical support, scientific information. And I'm going to just sort of pause for a moment and go back to what I said at the beginning. Human rights law gives us a lot. Whether or not people listen to it is another question. So yes, this is great, but the question then becomes, what do we all do to make this more real for human beings? And the last thing I just want to say, because I said I'd talk a little bit about what's already happening. In 2023, as Nadim said, I've worked a lot on Yemen. The Committee on Economic, Social, Cultural Rights, which regularly reviews countries, and they had actually paused reviewing Yemen because they said, well, it's a conflict. How can we actually think about socioeconomic rights during conflict? It's hard for the government. And what activists did is they said, no, like socioeconomic rights matter. This conflict has been going on for a very, very long time. We need you to review it. And they ultimately did. And in their concluding observations, which is basically their decision that they then put forward and say, Yemeni government, this is what you need to do. They not only talked about the impact of climate change on socioeconomic rights, they talked about the impact of pollution on socioeconomic rights, specifically referring to the Safar oil tanker, which some of you may have heard about. They talked about water and what the government needs to be doing on water. And given the conversations we were having on remedy and reparation, they specifically said that there are obligations to provide remedy and reparation for socioeconomic rights violations during conflict. And this is pretty good because in addition to being slow on the game for climate change, sometimes human rights bodies have really centered criminal accountability over reparations. So it's quite a nice thing to have this body come out and say, we want reparations for socioeconomic rights. And Nadim wants me to be quiet. So that is the end of my first intervention.
No, I just want to, I'm trying to keep time and get all of you to your right to food at lunch at a decent hour. But I just want to build, and I think this is bouncing on something you said that's very important, Christine, and I think Mais mentioned it. Human rights law continues to be applied even during conflict, right? And I think this is a very good example from Yemen. And as we started yesterday talking about the need to break the silos, as well, for many of you in this room working on environmental issues, I think there is a perhaps belated but increasing realization in the human rights movement that they also need to start engaging more. And so I think you will start seeing more human rights activists in that space. Now, Christine, you mentioned the right to water, and we're going to go now to Zaki Shuber, who is also a lawyer and specializes in national and international water law, conflict resolution, and strategic foresight. And she's right now completing her PhD in London on the topic of international law and uncertainty in shared freshwater resources, something that's already come up multiple times in our conversations on Iraq, but also Syria. And she was a practicing lawyer in Geneva and London before working as a lecturer in law and water diplomacy at Delft Institute for Water Education in the Netherlands. Zaki, maybe if, can you tell us a bit more? I mean, we heard a bit about, international humanitarian law. We heard a bit about human rights law. Maybe walk us a bit more on, is there specific international law related to water rights, other issues, environmental specific issues that people should be familiar with?
Thanks for the question, Nadim. I'm going to do two things. I'm going to talk a little bit about the puzzle that Christine talked about, just to set the scene a bit, and then I'll move on to water law. And to introduce what I'm going to say about this general framework, the puzzle of the environment and the law, I'm going to ask you a question or remind you maybe of a question that you've heard in relation to lawyers. What's the favorite answer of a lawyer? It depends. Yes. Why does it depend? For three reasons. So we have to make a distinction in order to be able to determine the relevant laws that will be applying to many of the situations that we've heard about today and yesterday. And to do that, we need to look at the subject matter. Which aspect of the environment are we talking about? What's being affected? Who are the actors? Are we talking about individuals? Are we talking about corporations? Are we talking about the state? Are we looking at the public sector, the private sector? And then the third point is, which level are we looking at? Are we looking at the national or local, the international, or even what's called transnational law, where a private actor is in an international setting, and that has ramifications that we can talk about later. And then I just want to say, in terms of the subject matter, we've already heard that there's the law of war, international humanitarian law, human rights law, environmental law, of course, and within that, water law, which I'll talk about in a minute, but mining law, energy, administrative law, criminal law, economic law, all may have a role to play and may offer avenues for remedy. Moving on to water law. So, a very big topic to talk about. I'll start by saying that this year for the UN, the theme of this year's UN water program is water and peace. There's a lot of, or there has been a lot of talk about water wars, and you may know that there has not been any water war so far, or any war where water has been the sole reason for going to war. And so I'm not going to talk about that particular aspect. I'm going to talk generally about international water law and the role that it plays as a mechanism to prevent conflicts between states by facilitating the way in which they engage and by setting out some rules at different levels of international law, but I won't bore you with the detail. But there are two important principles: equitable and reasonable utilization, and in relation to the topic that we've talked about, the no significant harm principle, which is the idea that activities on one state, on the territory of one state, will not have a negative impact on other transboundary states, on other riparian states. And the key here is substantive harm. So there is a certain threshold, which is a subjective threshold that needs to be passed. And if that is passed and the riparian states consider that there is harm, then there is a breach of international obligation. I don't think I have much more time left, but I just want to say that there have been wars where cooperation between states has carried on. And I also want to highlight, picking up on international humanitarian law, the Geneva list on principles on the protection of water infrastructure, which is a recent development, which is guiding but not binding principles on the protection of water infrastructure and in the environment as well as part of that. States are encouraged to abide by those principles, which I think is an important development. There have been other developments that maybe we can talk about, but I'll end here.
No, thank you very much. And I think that's very important. I mean, yesterday we talked a bit about, for instance, Israeli attacks on water infrastructure in Gaza. We've seen it in the past as well in Lebanon. And these are just tools, arguments that one can use in different fora. I want to move slightly now from the international to the national level, and talking to Shahinaz Adel, who's a Egyptian lawyer at Ahmad elSeidi law firm, which is the only firm. Sorry. Yeah, okay, Shahinaz, which is the only association in Egypt who works on environmental rights and environmental law, and especially trying to hold multinational companies and obligate them to respect environmental conditions and policies. And for you, Shahinaz, if you can tell us a bit about, so you're working within a national jurisdiction, in this case, Egypt. What, is Egyptian law sufficiently developed? What parts of Egyptian law are you using? And do you feel it's giving you sufficient tools to hold perpetrators of environmental crimes to account, or at least to stop environmental violations? All in, as well, sorry, 5 minutes.
more اوكي. اوكي انا هتكلم بالعربي. تمام. اولا حابه اشكر ARI استضافتي بالمؤتمر النهارده وامبارح علشان نتكلم على ال environmental violations. وحابه اعرف نفسي سريعا. انا محاميه بيئيه بشتغل في مكتب الصعيدي للمحاماه. احنا بنشتغل على التقاضي البيئي والمناخي، والمكتب عندنا هو الوحيد في مصر اللي بيشتغل على القضايا البيئية والحقوق البيئية. وبنستخدم التقاضي للوصول للحقوق البيئية طبعا. بنركز في شغلنا على تلوث الهواء والمية، بالتحديد التلوث اللي بيحصل من شركات متعددة الجنسيات واللي كمان بتساهم في صنع السياسات والقرارات البيئية بشكل كبير جدا. احنا بنحاول بشكل كبير نعمل توعية للقضاة بالقوانين البيئية، وحابة أدي إكزامبل على ده. يعني مثلا احنا كان عندنا قضية رافعينها علشان قطع الأشجار في حي من أحياء القاهرة اللي هو مصر الجديدة. فاحنا لما قدمنا مستندات وكان من ضمن المستندات ورق صور قطع الأشجار قبل وبعد مثلا. فالقاضي كان شايف إن إحنا عندنا وقت كتير جدا في إيدنا وإن إحنا جايين يعني بنتكلم في تفاهات. فللأسف الشديد يعني. بس وكان بيتكلم كمان في الصفة والمصلحة وإن إحنا إيه مصلحتنا أو الصفة بتاعتنا في إن إحنا نرفع دعوة زي دي، مع إن الدستور وقانون حماية البيئة في مصر بيتكلم بشكل صريح جدا عن إن أي مواطن يقدر إن هو يدافع عن البيئة بتاعته. فأنا حابة دلوقتي أتكلم عن التقاضي البيئي والمناخي كوسيلة للحد من الانتهاكات البيئية. في معظم القضايا اللي احنا شغالين عليها بنركز على دراسة تقييم الأثر البيئي أو ال EIA studies، لأن ده من وجهة نظرنا أهم إجراء. لأنه أي شركة أو مصنع بتفكر إن هي تعمل أي مشروع أو تعمل أي منتج عامة لازم تمر أو تعمل ده كأول حاجة. واللي بتحدد كمان إن المشروع ده هيتم ولا لأ. وكمان هو مهم جدا ليه؟ لأنه بيسمح للأفراد إن هم يشاركوا في صنع القرار. في الجزئية دي احنا عندنا طبعا مشاكل. منهم أول حاجة ده سؤال يعني هل الشركات أو المصانع بتعمل الدراسة دي ولا لأ؟ ثانيا لو عملوه هل بيحترموا أو بيراعوا الإجراءات القانونية؟ تالت حاجة للأسف التقييم ده مش بيتكلم عن الأثر المناخي، وأحب هنا أنوه على إن أغلب التشريعات مش بتتكلم عن الأثر المناخي. طبعا الإجابة على السؤالين اللي أنا سألتهم قبل كده هي لأ، ومن هنا طبعا بتبتدي المشكلة بتاعة الوصول للمعلومة أو access to information. من هنا بيبقى إلزامي كمحامين إننا نطلب تصريح من المحكمة علشان نقدر نوصل للمستندات والمعلومات المطلوبة الخاصة بالشركة اللي بنقاضيها. وده اللي بالفعل واجهناه على أرض الواقع في أكتر من قضية، ومنهم الدعوة اللي رفعناها على شركة لافارج الأسمنت طبعا اللي موجودة في مصر، يعني هي طبعا ليها فروع تانية. والمشكلة دي للأسف بتنبع من إن الأفراد أو الأشخاص غير ملمين أو غير واعيين بحقوقهم البيئية. وهنا هسأل سؤال، إيه هي الحقوق البيئية؟ طبعا إحنا في تعريف لده. الحقوق البيئية هي حق المواطنين في إدارة مواردهم الطبيعية بشكل يضمن استدامتها. وخلينا ننوه على إن الحقوق البيئية هي ترجمة لحقوق الإنسان. لأن عندنا يعني في حقوق الإنسان يعني عندنا الحق في إن إحنا نشرب مياه نظيفة، الحق في سلامة الجسد، حرية الحق حرية التعبير، والحق في اختيار النظام السياسي. وطبعا أهم حاجتين طبعا إحنا بنتكلم عليهم النهاردة، الحق في المشاركة والمعلومة، والحق في بيئة صحية وسليمة. فكده أنا هكون بوجه كلامي لحتة إن الموارد مش ملك للحكومة، وإن أنا كفرد من المجتمع أنا من حقي إن أنا أدير المية والهواء وليا الحق في صنع القرار. وده بيحصل إزاي؟ ده بيحصل من خلال ال public participation sessions أو ال public hearing sessions، واللي هو جزء مهم جدا ومتعلق بدراسة تقييم الأثر البيئي. وبالمناسبة احنا اكتشفنا إن هو لما بيتم عمل الدراسة دي مش بيتم إشراك النساء بشكل كافي. بعد كده أنا حابة أقول إن إحنا لما بنشتغل يعني على القضايا اللي زي دي إحنا بندفع فيها بأن مشاريع الدولة مش بتعمل تقييم أثر بيئي، وبندفع برضو بأن ببطلان المشاريع المصرية زي الكباري طبعا وقطع الأشجار، لأن ده بيعتبر أولا إهدار المال العام وعدم اتباع القواعد وكمان فساد إداري. سريعا هتكلم في نقطة تانية
ممكن بالجولة الثانية؟
sure okay.
Yeah, that would be great. شكرا. لا شكرا شاهيناز. وبعتقد I think you're mentioning something very important as well. How litigation in a national context can also help clarify concepts about who has standing to protect the environment. And I think it's something very important to reframe these issues. Laws are not just about going to court, they're about normative order. And to the extent that your litigation is pushing judges to question actually who has standing and to give meaning to these concepts of who has the right to, I think it's incredibly important. I think in the second round, I'm sure we'll get to more, very concrete examples about these things. And I want to now move to Farah al-Hattab. I'll introduce her in a second, but to really bring some of these conversations together. I mean, so we've seen different bodies of law. We've heard about different things. Do these exist in a vacuum? How do they intersect? And frankly, as activists, how do we make sense of all of this? I mean, is it a menu you pick and choose from? Do you kind of get inspired? And I think Farah is very well placed to answer this. She's been now for the last 2 years with Greenpeace International as a legal researcher, with a particular interest in intersectional environmentalism, movement lawyering, and anti-SLAPP initiatives. Anti-SLAPP initiative, it's something quite peculiar, I think, these days to Europe, where it's to kind of reduce the ability of polluters to slap defamation and other ways of shutting down critics. But she's been doing a lot of work on the detrimental impact of the fossil fuel industry, and using and mixing between an international law and a criminal approach. And she's very interested these days, and I think it's very much apropos to our panel today, to kind of think about the development of community-driven strategic litigation in the MENA region and the potential of such litigation to push the movement forward. So my question to you is really based on your experience. I mean, how do you think of these different frameworks that we've heard? And as an activist at Greenpeace, how do you use them?
Thank you so much for the introduction, Nadim. My job in general, I'm fairly recent to legal work. So my job is to take very complex legal concepts and try to translate them in a way that's understandable and easily graspable in order to be used in an activism and campaigning perspective. And it's also, it's not important if it's not graspable by the communities as well. That's our target audience. So, but I will start here by trying to mix a little bit about the puzzles that you have been talking about, and the puzzles being environmental law, in humanitarian law, water law, and as well as a national context. I want to introduce here a concept, and it's called the intersectional strategic approach. We are often asked about priorities, as we've seen in previous panels. Do we cut the trees or do we let the people eat? I think that this intersectional approach prevents us from having to deal with questions like these. And we do not need to compromise on the human rights and the environmental rights because they come together in a very strategic way. So intersectionality, if I want first to define it in very general terms, this intersectional environmentalism is a term that has been popularized by activists over the past years It is fairly recent in academia, but intersectional frameworks have been popular for a very long time in social justice communities. They are defined, intersectionality is defined by a critical framework that's used to understand people's unique experiences, risks, and resiliencies, and how they are shaped by multiple systems of power. Those multiple systems of power and oppression, they do not come in isolation. This is why it's very important to look at them from all aspects. And during our time here in this conference, I've noticed that we have highlighted two aspects of this intersectionality. The first one being yesterday and today in two or three of the panels. And this intersectionality is focused on the different disciplines and the roles that are played by active players here. For example, journalists and researchers such as Dana, Saada, Lisa, Abir, and many others. For example, they are documenting, quantifying, and qualifying the environmental degradation that is caused by Israeli systematic attacks on Palestine, Lebanon, Jordan, and other countries. They fulfill their role in generating the evidence, but they wonder that we have the evidence, now what are we going to do with it? And what we're going to do with it is what we saw happening in the recent case that was brought by Africa against the state of Israel in front of the International Court of Justice, where most of the evidence that we saw presented in court was actual evidence that was taken on the ground in Palestine by international organizations, but also by the people living on the ground. And this is something, we take the evidence, we build it from the community all the way up to the court. And another aspect of intersectionality where we make the puzzles meet is in the different legal disciplines. For example, we have tackled about all of these disciplines right now, and our job is to find a way to make them work together and to make the puzzle fit. And it is actually something that can happen because there are many examples in international law that we're going to touch on in our next part, and that's related to it. So what I'm trying to say in very simple terms is that it really takes a community, it takes a village to start a lawsuit from the bottom all the way up. And it's not something that just lawyers are supposed to do, because the lawyer is going to work on the practicalities of the law, but everything else needs to be built from the ground up and from all of the possible actors that could help on this. I would like to talk about another part that's related. Do I still have something? Okay. Amazing. I want to talk about my work with Greenpeace International over the past year. I have been part of a European fossil campaign, and my job was to take very complex criminal law concepts and try to simplify them in a way where it could be used in the campaign, but also in the very mainstream media. Because at Greenpeace, we have many social media platforms, mainstream or traditional, and our audience could be legal, very professional legal people, but it could also be very young Gen Z that has no idea about these legal concepts. And it has been very challenging to work on some concepts like these because we collaborated with legal academics and they provided us with an in-depth analysis of the law, but it was very challenging to make the campaign work in media terms. For example, we had to be very legally accurate, even though we're simplifying as much as possible. We still had to be very careful because the fossil companies that we were targeting, that not are based in Europe, but whose operations are mostly happening in the countries of Global South where they operate. They tried to intimidate us. They filed many SLAP lawsuits against us. SLAP lawsuit is a strategic lawsuit against public participation. It's used to intimidate, but it's also used to exhaust all of the resources and to take as much time as possible while drowning in legal fees and other stuff. And this is why it was very tough at the campaign level, but also on what was happening on other fronts. So I feel like this intersectionality was also very necessary in the work of the campaign because we were able to reconcile the concept criminal law, the complex criminal law concepts, and simplify them in a way that can be used in the campaign and promoted on mainstream media. And this is how another part of the puzzle fits, because we could do as much law as we want, but if it cannot reach the audiences we want to reach, it's not going to be very effective. For now, I will stop here, and maybe we can talk about other things.
Thank you very much. I think now we have a lay of the land. I guess let's. And now maybe we want to go a bit deeper, and we started talking about issues of, okay, you have the law, you're mobilizing. Which venues are you going to go to? But also, what does actually environmental justice mean for us concretely? Like, what are we hoping to get? You know, is it just a material compensation? How do we think about notions of reparation, notions of justice, but also in our context, if we all take a second and think, who are we trying to hold accountable? Is it a state-to-state responsibility? You know, so yesterday we talked about the example, for instance, of Lebanon trying to get compensation for the oil spill caused by Israel. Actually, one of the other, and perhaps the only clear example there was compensation for environmental damage was the UN fund that Iraq had to pay compensation to Kuwait for the environmental damage caused by burning the oil fields. Actually, a chunk of that compensation went to oil companies as well, not just Kuwait, but but this is actually the prime example of compensation in the region. So there is a precedent. You'll tell me it's quite political. Everything is very political, but who are we trying to hold accountable? Is it the multinational? Is it the a corrupt government? Is it individuals? Is it the multinationals? Is it national companies? So what avenues, what sort of remedies? And I'll turn to you, Mais, to maybe first start by talking again, maybe about state-to-state responsibility, and maybe you can bring your second hat of sort of experience now as well on the question of Palestine, but just more broadly, what does the law say in terms of state-to-state responsibility? See, here we're not talking about individual victims, but actually a country, it could be Iraq feeling that Turkey has violated its rights. It could be other forms of, we talked about the Kuwait, Iraq example. It could be, Lebanon with Israel and so forth. Over to you, Mais.
Yeah, thank you so much, Nadim. So there are actually two things that we could think of when it comes to state, actually two different branches of law. So the first one is international criminal law. Although we are basically looking at individual criminal responsibility, but it's a state-to-state kind of litigation, right? And when we look at criminal responsibility under international criminal law, we look at what are these violations that have happened during an armed conflict. So again, back to the international law of armed conflict, if there are certain sets of violations, then we want to take these violations and go to the International Criminal Court. The International Criminal Court doesn't really kind of prosecute a state. It does that as for individual criminal responsibility, and that goes to the military commander, for example, or the defense minister, and so on. But it's really interesting when it comes to environmental crimes. They are not particularly mentioned within the kind of framework of the International Criminal Court, right? So we have in general something that it's called war crimes, and these are these are grave violations of the Geneva Conventions, and among those violations could be extensive destruction and appropriation of property not justified by certain exceptions which the law permits. So thus we don't really see that the destruction of the environment as such within the framework of the International Criminal Court. But we can take it from a perspective of the environment as a civilian object. It's necessary for the survival of civilians. It was attacked, there is a violation, and so thus that would be more or less a criminal responsibility. I would like to mention one point that we talked about, that I've heard a lot yesterday, which is the term ecocide. The term as such has not been recognized as an international crime within the framework of the International Criminal Court. But there are really interesting examples. So for example, Belgium has enlisted ecocide as a crime within its criminal code, right? So, and then it also has been trying to advocate to the point that we want ecocide to be enlisted within the International Criminal Court statute. So there is some effort, but so far we still don't have ecocide as such as an international crime, but there are some countries who have listed it within their criminal codes. The other point, beyond the criminal responsibility, we have something in international law that it's called the law of state responsibility. And this is specifically, it's not criminal, it's very civil. So, for example, we want reparation for certain damages that X state has done to Y state. So back to the Lebanon-Israel example, Lebanon easily could go to the International Court of Justice, which the other kind of international body at the judicial level, saying that, well, look, we have environmental damages, we have been harmed by the Israeli attacks and so on. This is the evidence we have, and we are asking you as an international court of justice to rule on reparation. And this is basically what international law of responsibility is. Every wrongful act or every breach that does not fall within criminal responsibility, that we can actually go to another court and then say, we want reparation. Reparation means, for example, could be restitution, which is a term that describes the fact that the victim state could request to bring the situation back as before. So if there is an environmental harm, so we want environmental cleanup. And also there is monetary reparation, and this is something important, which is the guarantee for non-repetition, right? So we don't want this to be repeated at any point in the future. So these are very much the international kind of venues that I could think of when it comes to state-to-state relationships. Also, I mean, I think I shouldn't go to the national level, but also there are whole lots of examples on people using communities using international law in other courts to ask for reparations from other countries or companies. I think I'll stop here, and maybe I could elaborate on it during the question answer session, but I think I'll stop here with the two frameworks for now.
Thank you. I hope, yes. Thank you very much, Mais. So I think that's very clear. So the possibility when there is jurisdiction for criminal responsibility to go to the International Criminal Court, there is no specific crime, perhaps on the environment, but can definitely fit within general definitions of harm. But then state-to-state responsibility, in that case, you go to a court, which used to be really unknown. It's the other court in The Hague, but now lately got a lot of attention with the case that South Africa brought against Israel, the International Court of Justice, which does not look at criminal responsibility, but state-to-state relations. I want to move to Christine now and pick up maybe where Mais left us on on this notion of reparations. And I know it's something you feel very passionately about, Christine, and you've tried to push for reparations in the context of Yemen in different examples. And can you, and maybe now with your current role in Amnesty and how you're trying to think, I think of, let's say I'm an environmental activist sitting in this room, like, okay, all these lawyers telling me all these concepts, but how does that help me in practice? I mean, I've got, my river has been polluted, my wadi's been annihilated, they bombed our water infrastructure. How can you help me? How can I get a form of reparation? Does human rights law and human rights lawyers, are you helpful in any way? Can you just, sorry, I'm a recovering human rights lawyer, so I can make these jokes, but can you maybe just tell us a bit, because maybe we should start by saying, in a way, and this will surprise you, reparations law is having a bit of a comeback. It's a sexy topic for those of you who want to do a PhD, particularly, frankly, because of Ukraine. Because, you know, in law, like in everything else, there are power dynamics. And with the war on Ukraine, Europe and the West in general dusted off all the dust on reparations, which obviously were not mentioned when the US invaded Iraq and all of these things, but suddenly is like Russia's gonna have to pay, and they should pay. So suddenly the proliferation of articles about reparations, suddenly we talked yesterday about this international register. You've got Ukraine actually calculating, putting figures. As of last summer, it was already $51 billion of damages to the environment. So reparations is having a bit of a comeback. Would you agree, Christine? And can this comeback make its way a bit to our dear region?
And am I useful? No, so thank you for the question, Nadim. And yeah, I'm going to answer this based on basically before I was at Amnesty, most of what I was doing for the since 2016 was working on the conflict in Yemen with a variety of different hats. And then particularly over the last 4 years, working with a group of activists to try and push for reparations for conflict-related harms. Now, I have to acknowledge to the people in this room, we were not focused on environmental harms. So I meant it when I said I'm sort of late to the party. But what we did look at was something, for example, in the context of international humanitarian law, you have starvation as a weapon of war, as a war crime. And if you look at starvation as a weapon of war, which I'm assuming some people have been paying attention to in recent months, and if they're not, they should be, that looks at, for example, do you have an airstrike on water infrastructure? You could use that to make a starvation case. It could look at, have you been raising farmland? You could use that to make a starvation case. In the context of Yemen, we looked at, for example, the placement of landmines all around water wells that farmers were dependent on. We looked at Saudi UAE coalition airstrikes on water infrastructure and tried to understand what is the impact on local communities. Now, that's sort of putting that to the side for a second and just focusing really in on reparations. I'm going to give you the despairing, cynical answer, and then I'll shift to being hopeful. So the despairing, cynical answer is that if you look historically, the vast, vast, vast majority of any reparations that have ever been paid for any conflict went from the losers to the winner, like period, full stop. So even the UN Compensation Commission, Iraq paid reparations. Nobody else involved in that conflict paid reparations. It's just Iraq. It's not to say that Iraq should not have paid reparations. Absolutely, they should have. But the reason the UNCC worked the way it worked is it really focused on all the harm flowing from Iraq's invasion of Kuwait. So they skipped a lot of the complicated questions of, did you violate IHL? Because for the lawyers in the room, they really hinged it on the aggression, the invasion of Kuwait, and then you looked at the harm that flowed. You're seeing a very similar thing in the context of Russia-Ukraine. But then I'll get hopeful, I promise. But so a lot of the conversation around Russia-Ukraine is Russia invaded Ukraine. Now we're looking at all of the harms that have flowed, and Russia owes reparations to Ukraine. But if you think about reparations as you committed a legal violation, whoever you are, and you owe it to the victims, then this very, very one-sided approach will mean that the people who live in the country that lost the war often end up with no reparations. And that's kind of like one of the fundamental political challenges when we're talking about reparations, which is, and this is why I'm going to say human rights is useful. That's why I feel like you cannot look at reparations if you care about these questions from just a state-to-state responsibility perspective. You have to integrate the international human rights law perspective, because then you're talking about a bunch of individual claims to reparations. Maybe my state can represent me, but it can't give away my claims. I have a claim to remedy for the harm that was done to me. And the reason all this mattered in the context of Yemen is in Yemen, you have violations from the Saudis, you have violations from the Emiratis, you have violations from the Houthis, from the US. So you have a whole bunch of actors. And what would justify, from a human rights-based approach, just focusing on one of those actors? How do we exclude the other victims? But the things that I want to sort of end on being hopeful, to Nadim's point, when we started this work on Yemen reparations, everyone looked at us like we were frankly idiotic. They were like, there's no reparations, it's not a real thing. Yeah, sure, it's an international law, it doesn't actually happen. Ukraine happens, all of a sudden. We've got a UN General Assembly resolution that doesn't just say Russia is responsible for reparations for invading Ukraine. It also says for international humanitarian law violations and international human rights law violations. And it says reparations shouldn't just go to Ukraine, but should also go to people in Ukraine. Then you also see mechanisms set up to actually further this aim of reparation. So it's not just a resolution, you actually have a registry being set up that is specifically meant to take in the information about the damages that are being done, so that should there ever be a reparative process, you have it that this person's house was damaged and it was valued at this much, and this is how much they are owed. And you've had massive amounts of money and effort go into the Ukraine reparations effort. And in addition to that, again, back to political will, you have many amounts of seized Russian assets that people are saying they might use to provide these reparations. So they have this pocket of money that they could use to fund reparations. And similarly, on the Iraq example, part of the reason it worked is because they basically put a tax on Iraq's oil revenues for years. So what funded reparations for the UNCC was Iraq's oil revenues. And the percentage went down for a while, but it was a very significant percentage of Iraq's oil revenues went to the reparative process. Being optimistic, I think basically we don't yet have the tools we want to see, for example, a just approach to reparations in the context of Palestine, but we have a lot of building blocks and we have a lot of action, for example, on Ukraine that we can absolutely turn to and say, you can do it there, you're not doing it here. Will they do it? I don't know, but should we say that? Yes, we should. And in particular, because of what Mais said, the International Court of Justice has the power to award reparations. There is a case in front of the ICJ now, not just one, there's multiple cases in front of the ICJ now about what's happening in Palestine. So what are we doing now to ensure that should a judgment come out that finds a violation had happened, that reparations are not only provided, but they go to the people who deserve the reparations? And then the last thing I'll say on this is that sometimes I think we jump to assuming that the UN needs to set up some sort of mechanism for it to be effective or functional. But in the context of Ukraine, for example, you actually had regional actors in the EU play a very significant role in thinking about what are the institutions or mechanisms we want to set up. And you've also had civil society try and be creative about, if the international mechanisms are failing on the causes that we care about, what can we as civil society create? So in the context, for example, of Belarus, they created a civil society international investigative mechanism. It basically does the equivalent of what the Syria investigative mechanism does for anybody who's followed that. But the UN wasn't creating it. So they made a whole bunch of civil society actors who are collecting the relevant information, preparing the case files, figuring out, should we get fora that are willing to take these claims, we're going to be ready. And so I wonder if you push internationally, say, for example, for a registry on Palestine, Iraq. I mean, unfortunately, there's many examples from this region now that we should be pushing for. If the international mechanism, if the international institutions don't make them, are there regional fora, or can we as civil society think about what it would look like even if they don't go forward with those decisions?
Thank you very much, Christine. And also just a reminder, I mean, I should have mentioned as well, when we talk about criminal law, we're starting to see cases particularly in case of multinationals in their home country. So we mentioned it briefly yesterday. There's a case that was brought in January against Total Energy in France by Yemenis from Hadramaut for the role of Total Energy in polluting the water and affecting their livelihoods. We don't know how that case will go. It's still very much ongoing. Moving to Zeki, I want to talk, I mean, you work a lot on sort of conflicts around law between states, and we have quite a few of those in our region. And we talked today a lot about Iraq and the impact. Can you tell us a bit, I mean, what are potential remedies in these cases? You know, I mean, why can't Iraq, I mean, just in this previous panel, we talked about how Iraq is always begging Turkey to let a bit more water, or Iran give us a bit more water. Could they actually have gone to the ICJ or any other international mediation body or something and say, this is our fair share of the water, they've caused us a direct harm? You know, are there other mechanisms for mediation? Again, if you're an Iraqi activist that cares about the state of the marshes and you want to try to advocate and push for a national campaign to get the Iraqi officials to do something, what would you advise them? Are there avenues to kind of pursue disputes around water?
The short answer is yes, there are avenues. And in my previous intervention, I talked about the fact that there weren't any water wars, but that's not to say that there are lots of conflicts around shared waters around the world, or disputes, I should say, not armed conflicts. whether it's the Mekong with development upstream by China that's impacting the lower Mekong countries, whether it's the Nile, that's one of the very famous cases with the dispute between Ethiopia, Sudan, and Egypt. So there's quite a lot ongoing. And of course, it depends on how you define conflict or dispute. And I say this because at the moment, Switzerland and France are negotiating a treaty on the management of the Rhone River that they share. And you wouldn't think of Switzerland and France as countries that would normally have a dispute around water. But there is no mechanism at the moment that determines how Geneva operates the hydropower dam on its territory in a way that doesn't impact France downstream. And France is also in need of water and specific volumetric allocations. They want numbers, and the Swiss are not willing to give them specific numbers. So ongoing negotiations there. And so what avenues are available? Well, once again, it depends on the legal framework between the countries. So for instance, if we take the case of Pakistan and India, they've had a treaty in place since 1960, and that treaty has dispute resolution mechanisms within it. Typically, what you have is the first step, state-to-state negotiations. If that's not successful, you can bring in an impartial third party, a mediator, a facilitator. And if that's not successful, you can move on to adjudication, so going to court or going to arbitration. In the case of India and Pakistan, it's arbitration. And there's another mechanism as well, which I won't go into. But there was a case over 10 years ago, the Kishan-Ganga arbitration between the two countries around a dam that Pakistan wanted to build downstream of India. And so the dispute was resolved in that way. And adjudication also is possible. There are a number of cases. Since 1997, there have been a few cases around shared waters, the Danube, the Plata River between Uruguay and Argentina, Costa Rica and Nicaragua, where we also have exceptionally reparations, because reparation is generally not the focus in international water law disputes. The focus is more on, I would say, justice in the sense of equity in the distribution of water. And so in that one case, we have reparation, but generally that's not the focus, because what states want to do is to agree a framework looking forward with a number of operational details that are specific to the basin that they're dealing with. And if you go to court, you might end up with a judgment by the court that tells you, well, okay, we actually think that there are arguments both sides, and you need to go back to the negotiating table and agree yourselves what to do. That's what happened in the dispute between the Czech Republic, Slovakia, sorry, and Hungary in the Danube case. And a court will give you an answer on the law and on specific facts. So if you were looking for reparation, maybe that's where you would go. But if you want a long-term vision, if you want really to look into the future, you're not going to court for that. What you would want to do is sit down at a table, talk about the issues that you have to deal with, and find a way that works for you and your riparian countries to do that. So you fall back into diplomatic channels, and that's the situation of Iraq for now. So Iraq is suffering from decreased water flows from Turkey and from Iran as well. And the legal framework for Iraq is very limited. If we think of the relationship with Iran, there is a treaty that was signed in 1975, but its status is unclear. They could go to arbitration potentially, but then the question is, strategically, do you want to go to arbitration? You know, because that also sends a strong signal. But if you're trying to negotiate and your neighbor doesn't want to engage with you on those issues, you know, tries all sorts of negotiating tactics to avoid or simply won't enter into any discussion, there's actually not much you can do. I talked about Egypt earlier. Egypt has been trying a number of different avenues to try and engage with Ethiopia. It's gone all the way to the Security Council, and even the Security Council hasn't been able to force the three countries to negotiate an agreement that's equitable. There is no superior authority that can push states to agree a framework, a treaty between them, which is considered to be one of the weaknesses of international water law, unfortunately. And so Iraq is in that same situation of, going to Turkey, going to Iran, asking for water, but it's on an ad hoc basis. We don't have a framework that also includes Syria, because of course Syria is one of the water users of the Euphrates. And so there is no regulation. Things happen in a vacuum because there is political willingness at some point to release water, but there's no real agreement that gives Iraq and Syria, for that matter, really assurances of how much water is going to come. Processes in place for disputes also. The only avenue is negotiations at the moment. So it's a really complex situation, unfortunately.
Great, thank you. Maybe now, Shahinaz, you were talking about cases that you were bringing in local courts in Egypt. And I know you and I had discussed as well the importance of networking, and you mentioned that the case is not just the lawyers, it's the local community, it's the activists who've documented this. Can you tell us a bit more about concrete examples you've worked on in Egypt? What were the sort of remedies you were seeking? Were you able to obtain them?
تمام. طبعا أنا هرد طبعا على سؤال دكتور نديم، وهكمل يعني السبيتش بتاعتي. فاللي أنا هتكلم عليه دلوقتي المشاكل المتعلقة بجرائم البيئة. في مصر احنا عندنا مشكلة كبيرة في رصد الانتهاكات. عشان نحدد إن في انتهاك حاصل في منطقة معينة، ده بياخد وقت وبحث كتير مننا، وده راجع لفكرة إن الناس أو الأفراد مش واعية كفاية إنها تبلغ عن حدوث انتهاك بالمنطقة اللي هم فيها. وده بيوجهني طبعا للكلام عن المشكلة التانية، وهي الإلمام بالقوانين البيئية المختلفة. احنا عندنا 15 قانون بيئي بحت، منهم قانون الصرف الصحي، قانون المحميات الطبيعية، قانون الزراعة، قانون العقوبات، وده موجود عندنا من سنة 1937، واللي بينص طبعا يعني في legal text بتقول فيه إن اللي يقتل حيوان بيواجه عقوبة الحبس. طبعا قلة قليلة هم اللي عندهم إلمام يعني أو وعي بوجود القوانين دي. عشان كده احنا في شغلنا بنحب نركز جدا على أولا نشر التوعية، ثانيا التركيز على تنفيذ القوانين لأنها بالفعل موجودة بس هو محدش بينفذها. ثالث نقطة حابة أتكلم فيها هي التشبيك في العمل على القضايا البيئية. خلينا متفقين على فكرة إننا بنرفع قضايا بيئية من منطلق إننا نفهم الأفراد ونوعيهم بحقوقهم البيئية. عشان كده طبعا ضروري إن الجمعيات تبدأ ترفع دعاوى بيئية واستخدام التقاضي الاستراتيجي عشان نوصل للعدالة البيئية. برضو حابة أنوه على حقيقة إن كل الدعاوى البيئية بتكون تقاضي استراتيجي، بس للأسف هي بتاخد سنين ومجهود كبير جدا بسبب صعوبتها، يعني سواء بسبب صعوبتها سواء بأن في عدم تعاون من القضاء، وكمان لأن المحامي لازم يكون على دراية كاملة بكل اللوائح بتاعة الشركة اللي هو بيقاضيها، لأن هو لو مش عارف أو مش ملم بكل اللي موجود في اللوائح، الشركة هتزنقه وطبعا الموضوع هيفشل يعني. ف النوع من التقاضي ده بنقدر برضو نسميه تقاضي للمصلحة العامة. فاحنا يعني لما بنيجي نقول احنا محامين مصلحة عامة بيئيين. فالنقطة اللي بعد كده اللي حابة أتكلم فيها هي عن التقاضي المناخي، وحابة أقول إن مفيش حد في أفريقيا بيرفع قضايا مناخية، وممكن يكون ده راجع لحقيقة إن مفيش تشريعات بتتكلم عن الأثر المناخي. بس يعني إحنا شايفين إن التحرك في التقاضي المناخي لازم يكون بشكل إقليمي، ولازم طبعا يتم المطالبة بتفعيل إجراءات التخفيف والتكيف. وهدي examples على التقاضي المناخي، يعني مثلا عندنا الاحتفاظ بالوقود الأحفوري في الأرض. تاني حاجة رفع دعاوى ضد الشركات للتغيير من سياستهم. عشان كده طبعا احنا محتاجين يعني نعمل تشبيك عشان نقدر نعمل تقاضي مناخي. وبالمناسبة احنا بنقدم دعم وكمان استشارات مجانية للناس اللي حابة تسعى في هذا الطريق. وكمان بنوصي على فكرة التشبيك، لأننا مثلا كمحامين مصريين نقدر نرفع دعاوى في دول أخرى بالمنطقة طبعا. وده من وجهة نظري هيكون مساعدة كبيرة جدا ومفيد جدا لزملائنا مدافعين عن البيئة اللي في البلاد العربية الأخرى، لأن هيكون بالنسبة لنا إحنا بنشتغل من مصر هيكون فيه خطورة أقل علينا. وبتحركنا مع بعض أو إقليميا كده إحنا هنكون يعني بشكل ما بنضغط على المسؤولين وبنخليهم إن هم يتخذوا أو يلتفتوا للانتهاكات البيئية ويتخذوا اتجاهها طبعا إجراءات أو قرار. وده طبعا في وقت النزاع، أنا بتكلم على وقت النزاع.
شكرا زكي. بعتقد طرحتي موضوعين، زدتي على النقاش موضوعين اساسيين اللي هو مش بس التقاضي سوري ارجع على الانجليزي. You raised two additional points to our conversation. One is not just litigation for environmental damage, but actually starting to think about in the future, maybe starting from today, the issue of climate change litigation in the region, and two, creating this sort of middle stratum between the local and the international, and trying to figure out how lawyers in the region can start coming together to litigate in each other's sort of forms of regional solidarity. Zaki, and I'll conclude you this round, and then we're running a bit late. So just very briefly, in your own activism and in your own work at Greenpeace, have you seen how environmental law and strategic litigation provided avenues to stop the harm or not? And, you know, is there any particular jurisprudence that you find useful that it's worth sharing? And can I ask you if you can do it in 3-4 minutes max?
Can do it in less than that. I only want to draw some examples about some climate lawsuits were purely about environmental degradation and which led to a compensation or reparation because they happened in civil courts. There are many fossil fuel companies that were sued in the country where they are headquartered, but the defendants were people who came from the country where the environmental degradation occurred, such as, for example, in Nigeria, in Peru, also in Uganda and Tanzania. These types of climate litigation sometimes led to a compensation. For example, there's the one that's related to Shell in the Netherlands, who was ordered to pay 15 million euros. I'm not sure where that went, if they actually paid or not, but this is one type of climate litigation that can lead to reparation. There are two other examples of human rights-based climate litigation that's still in front of the European Court of Human Rights. One of them is Klimaseniorinnen versus the state of Switzerland. versus Switzerland. It is about a group of elderly women who took the Swiss government to the European Court of Human Rights because their health is threatened by heat waves, which are made worse by the climate crisis. And the heat wave is an extreme weather event that is happening in the MENA region. This is where we can start to draw similarities between international litigation that's happening and our region. The basis for this case was Article 2 and Article 8 of the European Convention of Human Rights. And it is about the right to life and the right for respect for private and family life. There's another example, and this is my last example, which is the Agostino and others versus Portugal and 32 other states, where it's also based on similar articles like Clima Seniorinen, which is Articles 2 and 8, and Article 14, which is prohibition of discrimination. And it's 6 Portuguese young people who filed a complaint in the European Court of Human Rights against 33 countries. This complaint alleges that the respondents have violated human rights by failing to take sufficient action on climate change and seek an order requiring them to take more ambitious action. So this is where we see that how human rights, youth and environmental rights, they all meet together in one type of strategic litigation, which is built in the community and goes all the way up into the court. And this is there are so many examples we can draw on the MENA region. This is not something that we can copy paste and bring immediately into the region, but these are there are so many lessons learned and ways of utilizing the international law that could very much effectively work in our region. And this is where most of our work is going to have to be.
Great, thank you very much. No, and just I always find these cases are not just about going to court. I mean, think about all the media attention that comes to it. So if one day the residents of Alexandria in Egypt bring a case because their city is drowning for climate change against others, it will just focus and everyone would start realizing that they're talking about these issues as rights issues and not simply as qada or qadar, as something that just happened to us, Really, thank you very much. And now I'm just going to go very quickly, sort of a quick round, and you'll each have a minute. I mean, I would want to hear your recommendations, 1 minute to 2 minutes. Clearly, there are major challenges, but you can see what a beautiful ecosystem could look like, right? We can imagine something in Yemen where between the mobilization at the local community, maybe satellite imagery that Vim is producing, maybe lawyers, everything comes together. There's an attempt to get reparations. Local communities are able maybe to stop or not. What would it take to build that ecosystem, to actually start giving meaning to this? We can think of examples from Gaza, Lebanon, Iraq, Syria, Libya, Egypt, so forth. So maybe just your recommendations, what you would like to see very, very concretely, 1 or 2 ideas of things that you say, if this happened, if we meet again a year from now, we would actually be a step closer to having litigation as a powerful tool to prevent, deter, hold accountable, and repair environmental harm, and use it as an effective tool for climate mitigation. We'll start with you, Mais, and really 1 to 2 minutes max, please.
Yeah, absolutely. Just as an international lawyer, I just want to tell people that international law will not solve all the problems, and it's extremely political. So you will see double standards, you will see biases. So I think, which is slightly weird that this is coming from an international lawyer, is that really the community, like the movements have to come from within. Speaking of Gaza, for example, we see this extremely political or politicizing the Gaza conflict or the Palestinian conflict. I don't like to call it Gaza conflict, but it's rather the Palestinian issue or plight. So I don't think that international law will solve everything. I think it will have to come within the Palestinian society as such. Usually, when we talk about Palestine, every single entity talks about what will happen to Palestinians or to Gaza or to the West Bank and so on. As Palestinians do lack agency, I think it has to come from within, because then people will have to see their needs, to see what affects them, and then to try to find the solution. And I agree with the other speakers that there needs to be a movement that everyone collaborates. And also that has to be at the national level, where there should be certain efforts to create a framework, not necessarily a law, but also measures, platforms, awareness, and then maybe the litigation could come slightly after if nothing happens. But really, my recommendation is that by awareness, movements will have to evolve from within. I stop here.
Thank you very much. So movement building with increased awareness and platforms. Over to you, Christine.
Okay, I'll go very fast. I think yesterday during the first session, when we were hearing about the efforts in Hadramaut from the local community, my immediate thought was, if this local community, and we don't know, like that's the first most important question, if they wanted to, this would be an amazing case actually to try and get in front of a human rights body, because they've submitted claims to the court and they've been ignored. And so it's a perfect example where there's already been wonderful local organizing, there's already been wonderful local documentation. And then the question is, would it be helpful to bring this additional level of pressure, this additional level kind of a rights-oriented approach that then kind of comes in at the Yemeni government level? And if so, yallah. So I think if next year we have identified 1 or 2 or 3 cases where a couple of us in the room are cooperating at the multiple different levels that we're talking about, and we try and bring it forward, and we bring it forward in a rights framework, I think we would have really moved ahead. Will it have solved all the problems in the region? Absolutely not. But will it have sort of gotten us a community that's actively working together? So not just talking, but like actively doing something together, and then operating at these different levels. Because to all of the points that my co-panelists have made, if it's one person, if it's one organization, it doesn't work. You just need all of these different levels of expertise, and you need to be doing it in a way that it's grounded, that it's going to keep going. And then I'm just going to say this, and everybody can ignore it if they want. But on reparations, there was a really cool effort by Caribbean countries a couple of years ago where they put out a 10-point plan on reparations. And what they basically said was, it's on slavery, it's not on environmental damage. But you could see a thing where something comes out of the region. I don't know if it's going to come out of our governments, but you could see something that comes out of the region and says, we want to talk about environmental reparations. This is to whom they should go to. This is for what damage it should be provided. This is who should be paying for those reparations. And this is what we need to see to get to this vision. And just providing a framework in which, like, how we are talking about reparations, frankly, can give a lot of guidance, including to people in the human rights movement. Because I think, frankly, and I really mean this sincerely, if we want to center climate and environmental questions in human rights fora, in human rights NGOs, like they need guidance, because I think they're really trying to find their way. And that doesn't mean that other people should do the work for them. It means they should be listening and learning, but it does mean there needs to be this kind of cross-section. Otherwise, it's not going to happen.
Great. So I retained 2 key ideas. Thank you very much. One is really on very concrete collaboration at multiple levels between local, perhaps, local lawsuits, foreign lawsuits, UN, human rights mechanisms, bringing them all together. I think there's a very concrete proposal on the table. And the second one, perhaps as a region that's been so affected by conflict, if there can be principles that come from civil society in this region, because I agree with you, I don't think governments are going to do it, about how they want to include and think about environmental damage and maybe push international law in a certain direction, I think that would be great. And maybe that's something we can think of. Zaki, over to you.
So I have 3 recommendations. Third one just came now. But the first one is, we've talked about documenting, and I think it could be helpful to document the puzzle, the legal puzzle that we've talked about, and bring all the pieces together, assemble them to get the overview, to understand how environmental harm is addressed in the region, nationally, regionally, and internationally. Maybe using a framework specific to the issue that's being considered, to also assess existing legislation and identify possible avenues. So the second one is based on a conversation I had with Shahinaz yesterday, and based on experience I have in the water sector, and that's judicial training on environmental issues. It's happening in the water sector. It happens a lot in the United States, for instance, and I think it could be interesting also to use that angle, irrespective of the state of the judiciary in the different countries, but raising awareness that way could help. And the third recommendation is based on the cases that we had today and yesterday. I was struck by the need to be able to engage with different actors, particularly in civil society. I think it was Sami's cases in Lebanon that really brought that to my mind. And I think training people to be able to have those discourses, to have tools to engage with civil society and stakeholders on these important issues could also be helpful and may be more impactful in the short term than the other two recommendations. Thanks.
Great, thank you. And just on your point of training, I mean, this region, we've seen over the last decade, a lot of training for judges on human rights. And we're starting to see, it hasn't radically changed things, but we're starting to see a lot more awareness. So Shahinaz's example of the judge saying, "Antu bta'milu eh hina?" You don't get this as much on human rights issues. So maybe something to do like this. And I love your example about kind of documenting all the environmental laws. We were looking at one point about laws in Lebanon, and it turns out the only documentation that was done was actually by a private law firm that was, selling it. So you actually had to pay a lot of fees to get access to all these laws, which are supposed to be public. So maybe adding to that as well, courses on environmental law more systematically in our faculties of law in this region. But really, thank you all. Shahinaz, أي توصيات عندك؟
أكيد طبعا يعني بحب جدا أأكد تاني على النقطة بتاعت إن إحنا كمحامين أو كناشطين بيئيين وكمان كجمعيات إن إحنا نبدأ نشتغل مع بعض وإن إحنا نبدأ في عمل تحالف، لأن يعني خلينا صريحين لما كل واحد هيشتغل لوحده ممكن يبقى فيه تقدم بس هيكون بطيء يعني. وإحنا حاليا في موقف محتاجين إن إحنا نتحرك فيه بسرعة، موقف مش مستحمل يعني. تاني حاجة هي طبعا ضرورة إنفاذ القوانين، لأن هي بالفعل موجودة طبعا بغض النظر عن جزئية إن مفيش كلام عن حتة الأثر المناخي، بس يعني نقدر إن إحنا نبوش for the advisory opinion من المحاكم الإفريقية، ودي نقطة برضو نحب إن إحنا نشتغل عليها يعني. ميرسي.
شكرا. لا، بعتقد موضوع التشبيك والتعاون أساسي فرح, last words of wisdom.
I think there's nothing more to build on that you haven't already, all of you already expressed. There's only one last thing, which is in order to build a climate litigation movement, we're going to need to be very patient, but at the same time, we're also going to have to define together what is our definition of a win. Are we looking for direct compensation, for example, for immediate action, or are we looking for a more jurisprudence way of finding landmark decisions and making them work? And those landmark decisions are going to help us, are going to be applied to every single climate litigation that we do later in the future. And this is what we should be considering. Thank you.
Great. No, thank you very much. So I'm going to open it. We have 10 minutes for questions and answers. So I'll go in the room. And if people have questions online, I will get them on my WhatsApp. So yes, please, Sada.
هو شوي سؤال ربطا باللي حكته شاهيناز، إنه لما حكت إنه الموارد الطبيعية هي حق الناس، حق الناس إنه تكون الدولة عم بتحط سياسة إنمائية مستدامة، ولكن هذا يتناقض، مش ملك الدولة، ملك الناس اللي هي لازم تستورد هذا يتناقض مع المفهوم تبع الحق والحقوقية. يعني بيروت بتشرب من جعيتها، المورد الأساسي تبع بيروت، ما بيحق لهم أهل جعيتا يقولوا إنه هذا مثل القانون الدولي تبع الأنهار، إنه هيدي النبع الأساسي من عنا، فأنا بدي أخده ومن بعد حاجتي أعمل بيسين وأعمل جازون وأعمل كذا. يعني الموارد المائية لما بتكون بإيد سلطة شفافة تتحمل مسؤولية المواطنين والمصلحة العامة والتنمية المستدامة، هون رأي المواطنين بيكون ثانوي مش أساسي بتقرير المصير تبع الموارد الطبيعية. بس أنا حبيت كون عم بتأكد من هذا الشيء اللي حكيتيه، لأنه برأيي أنه ما كتير ظابط كان، فبحب أستوضح شو قصدتي أكتر.
ناخد بس جولة أسئلة بعدين نرجع. مساعد بعدين حنحط هوني بعدين.
شكرا كثيرا. I learn a lot about the legal things related to water environment. Thank you so much. And there are a lot of things still not clear. And my question is there any framework to measure the war impact on environment and natural resources? Because it was hard to find something related to this. And maybe to cultivate a part of this great workshop, maybe we can have joint publications or policy brief about this legal issues in Yemen and Iraq, and to apply such nice recommendations, which will help, I believe, the local societies, because the impact in Yemen, for example, it's not only in Hadramaut, but also in Shabwa, in Marib, from the same French company. So maybe we have to have more civil societies from other governorates beside the government itself. And my last questions for Shahinaz: who are your customers, who you are working for? Thank you.
شكرا. هناخد بعد سؤال وناخد نفتح على شكرا حمزة.
Quickly, so thank you for a very interesting discussion. I think it's a quick comment on Zaki's notion that nothing can be done on water diplomacy around the region. And here I think we need to move away from the water diplomacy per se, where two countries need to agree on something, because let's agree, this is extremely political decision, if the two countries, they want to together or not. However, the best practice all around the world, that you have a basin. You look at the basin, you don't look at specifically water allocation, because if you stuck at only water allocation, how much you get and how much I will get, I think that is a short-handed understanding of the entire ecosystem around the river. Usually there's a basin, and basin, it's usually a wider area. So usually the entry points would be around understanding costs and benefits between these two countries. So for instance, for Iran, okay, I don't give you water to Iraq. That means more droughts for you, but that means also more sand and dust storms for me. And here comes more of the cost and benefit analysis. I think as very good entry point for that, because yes, water diplomacy is stuck. Thank you.
Okay, so I'll go back to the panel. I guess there were questions for لشاهيناز، كان في أسئلة وكان في لزكي تعليق. إذا بتحبي تزيدي شيء زكي بشكل سريع تنفتح كمان بعدين مجال. وبس على مساعد، احنا عندنا جلسة بعد الغداء، بعرف انه انا عم بنتهك حقوقكم بالاكل حاليا، بس بوعدكم بعد 5 دقائق رح نوقف. بس بعد الغداء حيكون لي الغوص ب يعني ورك شوب ستايل، كيف نطلع بتوصيات، كيف نبني على هيدا
تمام. انا حابه ارد على سؤال حضرتك. طبعا ايوه حضرتك عندك حق، التنميه المستدامه. هو اللي حاصل دلوقتي ان الحكومه اوكي بتتعهد وبتقول ان هم بيعملوا تنميه مستدامه، بس اللي حاصل ان في تنميه منقوصه. يعني احنا ما نقدرش برضو نقول ان الحكومات بتعمل التنميه المستدامه بشكل صحيح. بس بالنسبه للسؤال التاني، احنا بنشتغل لمين او مين الكلاينتس بتوعنا؟ احنا عندنا يعني بنستقبل قضايا وشكاوى من الناس اللي مثلا في ناس بتيجي تبلغ عن قتل حيوانات مثلا في نيبرهود معينه او كده. بس احنا بشكل اساسي بنشتغل باسمنا احنا، لان احنا يعني حتى احنا بنقول على نفسنا انا محاميه حره. يعني احنا بنرفع القضايا باسمنا احنا، وحاليا احنا في بروسيس ان احنا نعمل organization للenvironmental rights، ومنها نقدر نرفع دعاوى باسم الاورجنايزيشن دي. بس كده.
من بيدفع لكم؟
والله يعني احنا مفروض يعني بنستقبل الدعم ومساعدات من كذا يعني جهة، بس للأسف هي مش disclosed with me يعني ميرسي.
زكي موضوع
Yeah, very quickly. So I talked in very general terms about international water law. There's customary international water law. There's conventional. You have two universal conventions: the 1997 Convention on the non-navigational uses of international water courses, and the 1992 UNEC Convention on the use and on the protection and use of international watercourses and transboundary lakes. There are about 45 signatories to the 92 Convention, 37 for the UN, the 97 Convention. So it's still a minority of states that have signed up to these two agreements. In the region, we have Iraq, which is a signatory of the 92 and 97 Convention, and Syria, a signatory of the 97 Convention. But as far as I know, no other country so far. And in addition to those legal frameworks, conventional, universal legal frameworks, in terms of natural resources, you have a variety of other legal frameworks around biodiversity, illegal trade of species, transport of hazardous substances, air protection, and climate change as well. So that's why we talk about a puzzle, because you have many different pieces. And sometimes they work well together, sometimes they overlap, sometimes they contradict each other. So to understand how they relate to a region or to a country, you have to do quite an extensive legal analysis. But we can talk about it.
Your lunchtime is a great
at
way
lunch.
to time.
And then I just want to respond to the question about water diplomacy. And yes, I mean, we've had too much of water diplomacy. I think 2 points. I mean, transboundary water cooperation is about water resources management. And to some extent, you have to have processes around the water that allow the different riparian countries to be able to do their own planning and their own management. And that's why you still have to talk about water. But of course, equitable and reasonable utilization takes into account a number of factors within the basin and how you can use that water to the benefit of the countries. And you have examples of cooperation. For instance, Canada and the United States have an agreement over the Columbia River, whereby water is stored upstream in Canada to protect downstream US territory from flooding. So it's flood control, flood mitigation. In return, or as a result, the US has been able to build hydropower plants on its territory, and it has been giving half of the power produced to Canada as a way of compensating, or a mechanism that works for the two countries. Having said that, they are renegotiating the treaty because the US thinks that that share of the hydropower is not fair anymore.
On that one, no.
But that, you know, yes, you can look at a much wider set of factors to help the countries negotiate and not just look at the water, but you have to take it into account as well.
Thank you. So I know, okay, I'm gonna go to the table there, please.
Yes, yeah, it's working. First of all, thank you for the outstanding panelists. Honestly, it was a wonderful session. I think a few things. I want to start with what Farah said. I think it was very inspiring regarding documentation. It's something that we touched upon, I think, yesterday a little bit. And I think also there have been cases where there has been success to a certain extent, I think, in the global south in general. And you mentioned some examples. In Palestine, for instance, I mean, we're not new to the game in any way. It's been sort of frustrating that it's not leading to actual results. But as you guys said, it's not as clear cut. It's a puzzle. It's a political game in a sense. But when we talk about business and human rights, I mean, it took years and years. But finally, we have a list from the UN. It took a long time against companies that are complicit in settlements and so on. And this took a lot of work and documentation. And the same sort of means of documentation is being used also for, you know, special rapporteurs, reports, and other UN mechanisms, the investigation, the ongoing one onto Gaza. So I think it is an ongoing process, and there's things that come of it. When it comes to climate also, when we look at loss and damage, I mean, 20 years of fighting, And okay, still, we're not, we don't have it's not enough money, and we don't know the mechanism exactly, but the Caribbean countries that you guys mentioned, I think, I mean, this is absolutely needed as a means of reparation. I think we can consider it, qualify it in that sense. But for me, I don't know, I want to ask the panelists, whoever would like to address this. Does it feel frustrating now? I mean, we talked yesterday about following the path that Ukraine opened up new paths in terms of the registry and so on. Does it feel frustrating that we are playing somebody else's game in the MENA region, the global south in general, but let's put it that way, that new mechanisms, yani, subhanallah, are created yani, when Ukraine is under this situation? I mean, of course, it's important work, what they're doing, and they deserve it, but there's so many cases in our region that should have received reparations. So is it humiliating that we're playing this, let's say, the game of Western governments? And do you feel like they're embarrassed at level now where we can put enough political pressure to kind of balance this game a little bit more? Just a broad, sorry.
A very important question. Lisa, do you have anything to say? And then I think we will close the questions.
Yes, thank you. I'll echo what everyone else said. Thank you all for the very insightful discussion. And I just have two quick questions. One is about reparations. So we talked about restitution, and I think in an ideal world, restoring the environment to how it was originally would be perfect. But in a lot of conflicts, like environmental damage is sometimes irreversible, or it can take decades and decades for it to be restored. So then we move to monetary compensation. And is there any framework or are there guidelines for how we evaluate the economic value of environmental damage? And then the second one is about accountability. So let's say that state A persecutes state B, and then they win the case and the court puts out orders. Is there any mechanism that ensures that state B actually complies with the orders? Are there any consequences, or is it just like shikli, or I don't know what it is in English, but yeah.
Great. So I'll go back to the panel if anyone wants to answer any of the questions. And Mais, if you want to answer anything, just jump in, unmute and go for it.
Shall I start or?
Go ahead. Floor is yours, Mais.
Oh, thank you. These are really very important questions. Whether we feel frustrated about what's happening. I think that I go back to what I said at the beginning, saying that international law is double standard, or actually the way we implement international law in double standard and biased way. This is the frustration, or this is where the frustration comes from. I always say that in every single thing we do, we need to have a context. If we are implementing something in Yemen, I do not think that it would particularly, like, identically work in Palestine, or work in Jordan, or work in Egypt. So I really think we need to contextualize the what we have on the ground, and then there we could do something. But there is nothing that prevents us from being inspired by what is happening around us, around the world. And I think here the Ukrainian example brings, or it actually exposes how the international community could do something, although that would maybe take me to the compliance question, but it's at least there is something that could be done, and then we could even show the hypocrisy and the double standards that are basically going on at the international level, and particularly from what we see from the global north. That gets me to the question of, I'll just take your compliance question, if I may, and then I will leave the rest for the other speakers. The international law in general has a problem with compliance, right? So we don't have a particular kind of enforcement mechanism that we say, if you are not doing this, then we have that particular measure that we will take against you. Let's take, for example, the South Africa case against Israel on genocide. There were some provisional measures. They were legally binding. Israel didn't really care, and they didn't do anything to prevent genocide, right? They submitted the report. It was not publicly accessible, and then South Africa will have the time to reply to that report. But even if eventually after 5 or 6 or whatever years we will have a decision from the International Court of Justice saying that there is a genocide, and there are certain things that you ex-state have to do in general, then we will be in the same puzzle where we are like, okay, where should we go if the convicted state, let's name it like this, would refuse to comply? We can go back to the Security Council, and the Security Council, we know that there are these 5 veto powers that would basically get us again to the same circle, which is the problem with the Security Council and the de-democratization of the international order. So again, I really think that that's why I said at the beginning, international law will not solve all our problems. It might give us some means, but I really think that certain things should be within. So I stop here.
Wants to say anything? Any last words of wisdom?
Why do I always get the last words of wisdom? There's nothing really much to add about your question other than I do share the frustration that in the MENA region, it seems like we are not blessed by the oil that we have and all of the natural resources that we have. And it seems like it's always things being done to us rather than us doing things. But this is not something that we are only dealing with. All of the other communities and all of the countries of Global South are going through the same exact thing. And they are finding ways around it, even though it's taking a lot of time. And I think we could do the same. We have a lot to lose because, as we've seen in the previous panels, things can get bloody in this region, particularly, and it is happening right now. It's a tough fight, but it's not fully lost. I feel that's my last.
Okay. So if you allow me, as a recovering lawyer, maybe I want to talk. I mean, look, fighting is a choice, right? I mean, I think we're all frustrated. I mean, it's by definition. I think if you're Palestinian, what can we say, you know? But I say that with this idea of, I think as a lawyer, you take whatever arguments and hand you're given. So whatever small crack there is, you try to do it. Is the system biased? Of course the system is biased. Can you have breakthroughs? There are. And actually, there's a very interesting effort in this period, because this is a period of big change, where a lot of people are actually going back and reading some of the history of international law of the last 60, 70 years. And they're discovering that actually a lot of countries from the Global South made very important contributions in the 40s, 50s, and 60s, and actually finding the minutes. We had sort of erased the contributions of Latin America. We had erased the contributions of parts of Africa and Asia to this. And sort of we're dusting it off. But this will require work under very difficult circumstances. But I think in a way it's a way of resisting, right? And I don't think anyone can teach the Palestinians how to resist. You guys have been doing it for a very long time. But on this, because I do hope this is a hopeful note, I come out of this hopeful. The road is long, tiring, hard, with no guaranteed success, but there's a lot of positive energy. The energy is there. But I really want you to join me in really giving a big round of applause to our fantastic panelists. Really, thank you very much. And sorry, now you're right to food and we will be back here in an hour and 15 minutes, right? So now it's 2 p.m. We'll be back here for the working groups at 3:15, and my apologies again for going overboard, but we did start an hour late. Thank you.